Hello friends, I am Dr. Lakhwinder Singh, Assistant Professor in the Department of Laws, Punjab University, Chandigarh. I am here giving the presentation on the concept of judicial review. The learners' outcome here in this module would be able to understand the concept of judicial review. They would be able to compare the position of judicial review in India with that of the United States and the United Kingdom. Learners would further enhance the knowledge on the judicial review of the state's legislative and the administrative actions. Now, in order to understand the concept of judicial review, we must know the meaning, that what does it mean for. The term judicial review, it means the power of a court to review and potentially strike down an act of legislature as unconstitutional and invalid. Judicial review, it is not a limited term, it means not merely a power of the courts to set aside legislative actions only, but also covers the power of the judicial review of executive or the administrative actions. Judicial review, it is different from right of appeal also. The courts do not act as an appellate authority while doing judicial review. In case of judicial review, the courts inquire how the decision was reached. The superior court scrutinizes the whole the decision making process and checks whether the decision was made lawfully or not. If the superior court finds the decision unlawful, it cannot make a fresh decision but sends the matter back to the decision making authority. Now, the doctrine of judicial review has been originated in the United States, and moreover, practices of the doctrine in the United States also influenced many countries in the whole world. In the year of 1803, in the case of Marbury versus Madison, Chief Justice Marshall, he emphasized on the judicial duty to pursue the Constitution in case where a statute is in conflict with the federal Constitution. Marshall further explained that the phraseology of the United States Constitution confirms and strengthens the principle that a law repugnant to the Constitution is void. All courts and other departments are bound to act under the Constitution. Judicial review in the United States has become a very significant weapon to scrutinize all kinds of state actions, legislative, executive and the administrative. Because of such power, the United States Supreme Court has made significant pronouncements and invalidated the state actions on the ground of due process clause. While overruling its earlier judgment of Plessy versus Ferguson, the United States Supreme Court in the case of Brown versus Board of Education invalidated segregated laws dividing whites and blacks and held that separate education facilities are discriminatory in nature. So, basically they invalidated the principle that is separate but equal treatment, and the United States Supreme Court, this court's creativity, it is also being reflected when it recognizes free legal aid in the case of Giddon versus Wainwright and other fundamental rights to the accused person in the case of Miranda versus Arizona. Similarly, in the United Kingdom, the scope of judicial review is narrower because Parliament is supreme over there. Parliamentary supremacy and the rule of law empower the courts to compel the government to act within their limits by legislation. The courts, they cannot substitute their views on the merits of government action for those of the government. However, in United Kingdom, the courts, they examine the actions of public bodies and protect the will of the Parliament. The courts check whether the bodies are functioning within the powers they have been given. If bodies act outside those powers, the courts consider it void as it is against the intention of the Parliament. In the very famous case, in the Council of Civil Service Union versus Minister for the Civil Service, Lord Diplock classified the grounds of judicial review under the three heads, that is illegality, irrationality and procedural impropriety. He also recognized that further concepts such as proportionality might evolve.